Welcome to LawPath's legal education videos. My name is Damin Murdock. I've been a lawyer for more than 10 years. Today we're talking about non-disclosure agreements and how they can protect your business. But before talking about how they protect your business, we need to talk about what they are. So a non-disclosure agreement is, in essence, it states that party A is delivering confidential information, which is defined, to party B. And party B promises not to use that confidential information for any purpose other than the specific purpose for which that information was given. So if party A is deciding to sell their business to party B, party A will give a non-disclosure agreement to party B, and party B will promise that they will not use any of the confidential information that they receive when they do their due diligence on party A, unless it's for the specific purpose of buying that business. But otherwise, they will not use the confidential information, and at any time, party A can ask party B to delete all the confidential information and return it to them. Now, the reality though is that that sounds great in practice, but in reality it's very hard to enforce. That's because confidential information is only protected in certain circumstances. Your confidential information is only confidential if it's only known by you. If that confidential information is in the public domain, then it's not confidential. So if you have a website, you're selling your business, and you say, we're partnered up with blah, blah, blah company, and these people are our suppliers, when you give them a list of your clients and a list of your suppliers to party B, and then party B does not go ahead with your business, and then calls your clients and your suppliers who are listed on your website, that's not a breach of your confidentiality agreement because that information was already in the public domain. So a confidentiality agreement only is limited to what is actual confidential and not in the public domain. And that is where it can be very difficult to prove. How do you prove that the information that you've given has been discovered by them purely because you gave it to them? Maybe they could do a Google search, maybe they can find that information out themselves, and if they can in the public domain, then you're going to have a difficult time enforcing that non-disclosure agreement. That's a one-way non-disclosure agreement. Another one is a two-way non-disclosure agreement, which is normally called a mutual confidentiality agreement. And a mutual confidentiality agreement is saying where while party A is giving information to party B is also giving information to party A. And you're swapping information, and the same thing at the end of the transaction, if the due diligence fell over and you don't go ahead with the deal, then at the very least, you'll return the information, you'll delete the information, and you won't use it against them. Now there's another document called a confidentiality agreement and non-compete deed, or a non-disclosure and non-compete deed. And a deed is something that's similar to an agreement, but the only difference is that an agreement is an offer, an acceptance, a meeting of minds so the parties understand what they're agreeing to, and consideration. Someone's giving up something for something else. So there's a benefit and a detriment. Now a deed doesn't require the benefit or detriment. So by doing a confidentiality deed where you're giving up your confidential information to somebody, but they're not giving anything back to you, there's no consideration potentially. And if there's no consideration, the entire agreement fails and it's unenforceable. So a lot of times I do a non-disclosure deed or confidentiality deed because you cannot necessarily prove that by you giving confidential information to them, they're giving up any kind of benefit or they're giving up any kind of detriment. So your detriment is giving them the information, but the benefit you're receiving is possibly uncertain. And if there's no consideration, it's not enforceable. So ideally, you would do a deed, which doesn't require that element. And next one is, most people enter into a confidentiality deed or agreement because they do not want that person who's getting that information to compete against them. They don't want them to steal their idea. They don't want them to steal their confidential information. So in that circumstance, if you're able to get the other party to agree, then you would give a non-compete deed. And a non-compete deed would actually say, not only are we giving you confidential information, you also agree that you're not going to compete with us for a certain period of time. Now, to convince the other side to agree to that is difficult, because the other side would say, but I don't even know what you're doing, so how am I agreeing not to compete against you? And the high-level answer would simply be, well, you are interested in what we're doing. You're definitely not doing what we're doing. You can see on our website what we offer, and you're not offering that. So if you want to see what we do and you want to get the details, then you got to promise that you're not going to compete against us for a period of time. So that is an added benefit if you can get it. Now, if you can't, the benefit of a confidentiality agreement or a non-disclosure agreement is that if you've given information, the transactions come to an end, and you believe or can prove that they're using your confidential information, then you can go to the Supreme Court of your state and seek what's called an injunction. That is, getting a specific order from the court that says that they must stop using it. And that means that that is very powerful in certain circumstances where you can prove that they've taken your information and now using it against you. And you can also sue for damages. And if you can show that the confidential information that they've received, they've now taken and used it somehow to benefit, then you can potentially sue for copyright infringement, which is, that was your confidential information. They've used it for their own use. It wasn't owned by them. It was belonged by you. Therefore, you can claim copyright ownership over it, and you can sue them for what's called account for profits, which is any profit that they've derived as a result of breaching your non-disclosure agreement. You can claim all those profits back from them, and damages. You can claim additional damages for flagrant infringement, and you can claim account for profits as well. So thank you very much. If you enjoyed this video, please make sure you subscribe to our YouTube channel and give us a thumbs up. If you have any questions, visit www.lawpath.com.au. Thank you very much, and I'll see you next time.